Kirk is not an attorney. This is not legal advice. This is to be considered for educational purposes only.
Welcome to Kirk's... Oh, we got some background there, guys. Watch out for that. Welcome to Kirk's Law Corner, live with your hosts, Kirk Pendergrass, Chris Hallett, and John Gentry. They're good, I think. Monstrosity. Yeah, that's... I don't know. Who's saying no sound? There's plenty of sound. What?
Out here on Facebook Live, they can't. There's no sound.
All right, I got it. All right, that's fixed. No, they're correct. There was something wrong, and I just fixed it. I saw what was wrong. I apologize.
All right, welcome back. We have audio. Thanks for joining us tonight. We have Chris Hallett over there, John Gentry over there, and John is going to start with his kind of continuing on from last week. So back over there to you, John.
Okay, so last week I'm going to start over. Last week we talked about how to file a complaint, the steps that you have to go through, proof of service, how to serve, how to file in court. Went through some of the basics, and we also went through some of the tricks that they try to use to deny us due process. Under the federal rules of civil procedure, it's really straightforward. You file. Jump down a little bit. Sorry. A pleading that states a claim for relief must contain a short and plain statement of the grounds for the court's jurisdiction, a short and plain statement of the claim showing that you're entitled to relief, and then the relief sought. And that seems like really easy to do. But if you're suing a member of the legal profession, if you're suing the state, they're going to do everything that they can to deny you due process. And so our complaints have to be picture perfect in order to have any standing. Because one of the first things they're going to do is say, oh, this doesn't satisfy Rule 8, motion to dismiss. The pleading is just insufficient. I can't even make heads or tails of this. So let's get into the construction of a complaint, because these rules only apply to them. Would you agree with that, Chris?
Yeah, as a matter of fact, it's funny you bring that up, because the first time you hear the words, this complaint is incomprehensible, doesn't make sense, you get that kind of language, you've nailed them right where they live. So just kind of so that's their go-to when you've hit them, and you've hit them good. So anyway, go ahead. I just had to make a funny on that because of what's been going on. But go ahead.
So that's one of the first things they throw out there to persons representing themselves, sui juris, pro se, and I always encourage people to file sui juris as well as pro se, like I did here in my complaint. So the first piece is titling your complaint. This I'm going to step off a little bit here, and just to say something interesting, something I found interesting. The agency that provides oversight and looks at, I think it's called the Judicial Commission. I don't remember the exact title off the top of my head. They said one of the biggest complaints is pro se litigants are angry, and the clerk's office is having to deal with angry pro se litigants. And so their answer to that, or their suggestion, is to provide more forms for pro se litigants. And if you go out and look at the forms that they have like this little tiny box, where you enter your complaint. And of course, then they just come in under Rule 8 and say insufficient pleading, motion to dismiss, and the court's granted. Okay. So coming back to the construction of the complaint is the court that you're filing in, and the title heading of your case. And I always encourage people, and you have to include this on your cover, you're not going to get a fair hearing, more than likely, if you put it to the court. So you have to demand a trial by jury. And that has to be done. It's required in the rules of procedure that has to be done on the cover of the complaint. I did a table of contents. My complaint is quite lengthy. It's a total of 103 pages in this particular case. But you don't have to do a table of contents. I recommend putting in the nature of the case, or the statement of the case. And this is just to say, here's what this is about. My rights were violated. My property was taken. My children were taken. I'm not being provided due process. Just a quick summary of what your case is about. Then you need to define the parties, including yourself. So you say, here I am. Here's where I live. Here's the defendants to the case, and you'll state that this is where this attorney or this person lives, resides, or works. If they're suing an attorney, their principal office is sufficient and being within the jurisdiction of the court. And then you make a jurisdiction statement and you say, something like I have here, I'm happy to share all of my work. This complaint that we're working with was filed in Middle District, Tennessee. It is available on Pacer and available for download from there. So this is free and available, or it's available to the public. It's a matter of court records. So I'm happy to send you a copy of it if you like. So state the jurisdiction of the court. And then I go through and I do a piece on general allegations. And this is something that's common to all of the defendants, and just general allegations of laws that were violated or crimes that were perpetrated against you. Let me scroll down a little bit. So I have in my case, I had 3 sets of general allegations in here. But yours doesn't need to be so complicated. Let me keep going down. So then I get to the causes of action. And I really like this format. Neither the courts nor the defendants in the case ever complained that my paperwork was not in compliance with federal rules of civil procedure. It was a pretty easy complaint to read and understand. And the format here, I think, works really well. Most of the formats that I use, I'm kind of monkey see, monkey do. So I'll go find a format, that was filed by a highly respected member of the legal profession, if there is any, or from a federal agency, and I'll look at how they put together their complaint. And I kind of structured mine off a few different examples like that. But I put in the laws that were violated and the specific parts of the USC that those are related to. And then I go through and state again the venue and a little bit of summary about how my rights were violated and that these created causes of action. Now, this is a key point out there. If you're a pro se litigant, more than likely the court is going to deny you evidentiary hearing. They're going to pretty much try to deny you any kind of hearing. So you have to get your evidence in. And I got this from Chris Hallett when I first started out. Chris told me, attach your evidence to your complaint. You remember that, Chris?
Sure do.
And the reason Chris told me that is he knew some experience that they weren't going to give me a fair shot. And this is one of the tools that they use to dismiss is you come in with your general allegations that I have above. They did this and they did that, and you state your causes of action. And what do they say, Chris? Conclusory and unsupported, right?
Oh yeah, or something to that effect. Yes.
So you have to attach your evidence. So, and also in my case, this case was about RICO and fraud and conspiracy to deny due process. And whenever you're going in a fraud or a RICO case, do like I did here, because under the fraud statutes, you have to state a time and a place where it happened and what happened. And so I'm very specific, and I say, on February 3rd at approximately this time, this happened, and here's the exhibit to support that. And then I attach that. In this complaint, like you guys saw, there's 103 pages in this complaint. There's 155 pages of evidence attached to it supporting my claims. And then the next section that I run through is the statement of facts. So here I went through and stated my causes of action. And I said, here's all of the USC that they violated in this case, the United States Code. If you're suing in federal court, you have to bring suit under federal statutes, and you have to state those statutes in your complaint. So I stated those here, and then I said, here's a summary of how they violated those laws. And then I come in with a statement of facts. And I come in and say, here's what's in the transcript, proving my allegation. And then I attach more exhibits to that. Your causes of action will be specific to each defendant. So I had four defendants in this case. So then I have a second cause of action, and you'll notice that these are different USC laws that were violated in my second cause of action. And then the same thing, so I went through and I said, here's how they violated those laws. And then I come back in with a statement of facts, proving how they violated those laws, and attached with evidence to it. Let me jump over, if I can, real quick, and bear with me.
Mm-hmm. Patty just asked a question. What if you have a case that was fraudulent in 2 states? The answer to that question is what you're basically having to do is you're having to disqualify both state bars. Okay. And I'm going to answer this because I just got some definitive answers on this. That's one of the reasons why me creating my company to do what it does, which is kind of tags on to the interstate commerce clause and says, look, the state bars have admitted that they can't cross state lines, but here's how they're doing it. And this is the reason we're no longer going to deal with the courts. We're going to go straight to Congress and show the Judiciary Committee, as well as the Interstate Commerce Committee and the various other committees, the exact process. Now, I don't know if you've seen it or not, the little loop-de-loops that I've done. I just sent in another report. Now, every time I send in a report, it's $140. So apparently a lot of people didn't realize that. So this is not a cheap proposition for me. But so I just sent in the report that outlines that process and explains why people are so caught up in these loop-de-loops. And when I showed them how I recognized it as something that I have also done in the past to solve a certain problem in the corporate world, that's how I recognized it. So that report just went in yesterday. It was on their desk this morning when they got there. So I'm expecting feedback from the various committees on that, but no, the end game is going to probably be a very anticlimactic contempt of Congress. And we'll discuss more about how that works on the Wednesday night show, because I should probably have an answer that I'll go over with everybody on the Wednesday show. So stay tuned for that.
So another piece, and I mentioned this on the last segment about filing and getting things file stamped. This is this is all of my evidence attached. I don't know if you guys can see this at the top, but it's 241 pages. And this was a copy that I downloaded from the court's website. This was made up of exhibits A through W. So what, 20 something or 20 or so exhibits I attached to it. They did this whole thing as document 31 or 32-1. So I had 20 something exhibits, and they did it all as one single document. These should be uploaded as separate attachments with a description of each attachment. And I think that this was probably not a lazy clerk. I think it seems plausible to me that this was a way to to make my evidence less obvious. So what I suggest to people is when you go into the clerk's office is ask the clerk, when you file this, I would like each exhibit separately file stamped and separately entered into the record. And here is how my intent of how I want each document titled. Because like for example, I filed a copy of the complaint I filed against a judge with the State Judicial Oversight Agency. They titled that document with a subject line that I had in it. When it, the description of it should have been complaint against judge, but instead they put in there like statement of something, as I recall off the top of my head. I don't remember it exactly. But they will try to title your documents so that they're misleading, so that people won't look at them if people are doing research on PACER. So I encourage you, get each exhibit file stamped and tell them how you want it to be titled as an attachment to your main document. Let me jump over. I think that's about. Kirk, that all makes sense to you on how to construct this? Do you have any questions on it, or do you think anybody else would have questions about it?
Well, one thing I was going to ask here is, like, when you're doing these exhibit stuff, I mean, it's the same in the state courts. You want to get them separate, but it needs to be incorporated into the paperwork. So, when you do a brief and you're quoting something, see something, here incorporated. Okay, so those two words need to be added there. See herein incorporated, or here incorporated, pardon me, or herein incorporated. If it's gonna go in as one file.
So I think that structure
list the name of the title of the document.
That structure that I showed you guys, naming the parties,
okay,
titling the case, general allegations, including evidence, refer back to this video, and it's a really good format to put your complaint in. And if anybody wants a copy of any of my work, just message me and I'm happy to send it.
Yeah. Let me try and get I couldn't get to my desktop with screen share. It will not let me go anywhere. I'm like, what the heck? So I just had to wait.
Hey, Chris, can I ask you a question about my Supreme Court case?
Certainly.
Let me share my screen with you again.
Wait.
Yeah. Wait, no. Oh, God.
If you go to screen share, I lose my screen. I can't do nothing. I'm trying to get that document. So once I get there, then when you're done screen share, and I'll screen share, but I'm almost there. Come on.
All right. So here's the United States Supreme Court. And here's one of my cases.
Man, why is this thing?
So you're looking at this main document. This is a motion to disqualify the Supreme Court justices because I believe the facts show that they have a personal bias and they're unwilling to enforce the Constitution against defendant judges and attorneys. And I made, it's 37-page document. And I made some really good arguments in this. Judicial and attorney misconduct wouldn't occur if judicial oversight agencies and federal courts were functioning as intended. That seems pretty reasonable to me, that the fact that our rights are being violated means that the federal courts are not enforcing the Constitution. That seems pretty plausible. Wouldn't you agree, Kirk?
It's very plausible.
And then Justice Gorsuch, our most recent appointee, he said that any attack or criticism on a judge is an attack or criticism on all the brothers and sisters of the road. So, I'm looking at that saying, how can I expect a fair hearing when you consider my complaint against judges a personal attack? And not only a personal attack, but an attack on the entire judiciary. And then the Supreme Court and their clerks, there was another case, and it looked to me like there was evidence that the American Inn of Courts pays for vacations for the clerk's office in the United States Supreme Court. And that creates a conflict of interest. That American Inn of Courts is a fraternal organization where attorneys and judges socialize. And it's to draw in law students, practicing members, all the way to the United States Supreme Court. And so, I'm saying I think there's a conflict of interest in there. And then I made an argument, and I said, the way things are going with the legal profession, you can't sustain this. People are going to rise up. People are going to stop going. You're not going to make any money. It's a bad business model. It ain't going to work. It's not going to work forever. So, stand with me and exercise your supervisory power and help return this country to the principles that we were founded on. Right. And then I did a section, a new aristocracy. And I said, for the federal courts to not enforce the Constitution against members of the judiciary creates a new aristocracy who are above the law. Many times they're involved in making the law, and they're not accountable to the law. And that's an aristocracy, And so I thought, and then I said, hey, if you can affirm your impartiality or evidence your impartiality and show me where you have enforced the Constitution against judges, I'll withdraw my motion to disqualify. So I thought this was a pretty reasonable motion to disqualify. These things concern me, and I deserve a fair and impartial court. So now here's the question, Kurt. Let me jump around here a little bit. So 28 USC section 455. This says that any justice, so that's the Supreme Court. Kirk, I'm gonna need your advice on this one. So the language there is very specific. So any justice, which means the United States Supreme Court, would you agree? Because they're justices.
Right. But it says judge or magistrate. So it's all of them.
Yeah. Okay. And so
that's, in the appellate Supreme Court or the appellate court, whatever district, judge of the Supreme Court.
So this is what I was asking them to disqualify, where they have a personal bias or prejudice concerning a party. And that's what I did, right?
Right.
Okay. So now let's go back and look at 28 USC 144. Now this is the question here. Whenever a party to a proceeding, I think I just answered my question. In a district court, files.
Well, the district court will be your first court you go into.
What's that?
Even if it's a Supreme Court, it's still a district court. Well, technically, you don't. It's a federal district court, and then you go to the Supreme Court when you get to the appellate court or the Supreme Court of the United States.
Right. I mean, basically, your cert into the Supreme Court is not unlike a notice of appeal.
Right.
Knowing that the U.S. Supreme Court is very selective and number one in cases that it will hear, but one of the main criteria that they look for is procedural error. And one of the it just came out in the ABA today. I should probably dig that up. Legal Journal just came out from the ABA, does show where there are multiple procedural defects, deficient pleadings entered by counsel. I mean, basically the article that I read pretty much pointed at the practice of law as if like it needed to go back to school, you know. And I was, as I was reading, I started to giggle, thinking of that joke that you and I tell all the time, Kirk. You know, it's like, did you go to law school? And if so, did you pass? You know, it's like to sit there and read this, knowing that we've laughed about it. I'm like, okay, where's the microphone? It's around here somewhere. I know it is. And, you know, so I just got a charge out of it.
So I'm guessing. So the rule says that when there's a motion to disqualify, that such judge shall take no further action therein, but another judge assigned to hear the proceedings. Does this not apply to the Supreme Court?
Well, again, the Supreme Court is a court of, they're basically where if you wanted to, like Brian Kinter says, if you wanted to take the court to court, for lack of a better expression,
right, that's
the quote unquote venue if you wanted to actually take them to court. But there's actually two ways to do that. Writ of cert to the Supreme Court, or a petition of, you know, whatever type under whatever congressional rule into the House of Congress. And if you can go through and definitively show a congressional committee that a reasonable person would probably conclude the same way you did, and pretty much everything you did was within compliance of the rules and, you know, was sufficient with the process, but you were still denied. And those are things that, believe it or not, that's information that the congressional committees are begging for, which is one of the reasons why I've agreed to say, look, I'll even pay whatever the fee is. That's why it's $140 to file through the portal. That's direct access to the congressional docket. That goes directly to committee. And because I'm willing to do that at my own expense, you know, to show them, look, A, B, C, D, here's what you guys wrote as the lawmakers. Here's what's happening in the courts, right? It's pretty simplistic. And to actually have a third party practice be able to come in and say, you know, hey, look, this third party practice is following the rules that we Congress made up, right? This is what we wrote. This is what we told the court we wanted to see them do. And they're doing this, and this, and this, and this. And you're over here and back over there. And this one can't find his rear end with both hands. When this stuff comes out in this form and fashion, you can expect some serious result, because you'd be guaranteed they're, you know, remember, they're lying to us and lying to Congress just the same. You know, oh yeah, Congress knows all about it. Sure they do. No, they don't. They're lucky. Congress is lucky to even know your name with all of the allegations that we're getting thrown at us on a daily basis, which is just,
so,
you know.
So technically, though, according to this rule, so they denied a motion to proceed as a veteran, and they did not issue any ruling that I know of yet on my motion to disqualify. So I'm thinking that they didn't violate the USC based on the technicality of this rule. Would you agree?
Yeah, absolutely.
So there, you think that you agree that they're in compliance with the USC when they did not rule on my motion to disqualify?
No, basically what they're doing is they're telling you by denial. What does the order say? Did you get the order yet, or just a denial?
No, it's I'll show you real quick. Maybe I can jump back to it.
Yeah, we're all slow learners. Stacy's saying we're slow learners. Yeah.
So
That makes two of us, Stacy. I've been doing this for 28 years, sweetheart.
There's so many different parts of the law, aspects of the law to try and learn.
This is all I'm aware of is, they just said motion to proceed as a veteran is denied.
Okay, so they didn't give you any explanation.
No.
Okay. No, then they're not following the statute. The answer's in the question.
This is your writ of certiorari, right?
Yeah. So, well, no. Their first is to rule on me to proceed as a veteran. So now they're gonna make me file 40 booklets with the United States Supreme Court, it's expensive. I actually got a quote from somebody today, and based on he said rough guess, based on the number of pages, $3,500 for them to print the booklets for me. $3,500, and I've got 2 cases, so we're talking like $7,000 just to file. That kind of sounds like a barrier of access to the courts. I mean, that's a lot of money. I'll do it for a lot less. I'll print them myself. But I was wondering, shouldn't they have addressed my motion to qualify before rendering a decision? Based on 144 says that a judge shall take no action. But it sounds like technically that rule is only pertinent to district courts. Not.
I was going to say we might look around some more and find one dealing with them.
Yeah, I'm sure I'll complain about it. I always about everything. So we'll see. Let me show you this just to give you guys an idea. So I printed off. This is a Supreme Court brief that is compliant with their rules. And so this one, I mean, it looks like a paperback book, right?
Yep.
So now, what's interesting about this is the paper that you use in this. It has to be on 60-pound paper. Pursuant to Supreme Court rules, it's got to be on 60-pound paper. It's 3 times the thickness of copy paper, and it's hard to do. I've got a really good printer, so I was able to do it. I'll probably turn these around in 2 weeks and get it right back to them, and it won't cost me anywhere near $3,500. I print these in house. I guess it's walk my stack of papers, but I've got a binding machine that made this. And this looks pretty professional, don't you think?
Yeah. Oh, yeah. I mean, what size is that now? You have to cut that down to what size?
Yeah, so they're specific. The width of it is 6 1/8. The height is 9 1/4. And then for the can't see that in my light very well. They say the margins here have to be 3/4 of an inch, but that's very misleading because they also say, and I don't remember the exact dimensions, but the width of the text here has to be, I think it's like 4 1/8 inch, which leads to a bigger margin than 3/4 of an inch. And then they also say the height of the text here can be no more than like 7 inches and a quarter or something like that, which also you can see that leaves a big margin at the bottom, right? or the top if I centered it top to bottom. But you have to have a minimum 3/4 inch. But with them saying also that there's a 7 and something inch limitation on the height of the text means that there's not really a 3/4 inch border. It's something different. Right. Does that make sense to you? So
yeah.
those are
No, it doesn't. It's actually by design to make you confused and make it more difficult for you to exercise your right to justice.
Well,
I'll just call it what it is.
Hey guys, can I interject real quick?
Yeah, let me jump off a screen share here. Or was
you're already off.
Thanks.
There's a lot of echo coming in from different devices. I don't know how Kirk has it set up, but for some reason, even though Kirk doesn't have headphones on, he's not getting an echo. But I'm getting a large amount of echo from you, Chris,
It's
and you, John, like very, very, very high, which makes it. And I've watched, I looked in on some of the shows while I was gone, but all of you need some kind of device, like I've got two devices in my ear at the same time, so I can hear what you're doing. I've got
So does
the
this sound
earbud.
better? Does this sound better? I turned down the volume on my computer so my mic doesn't pick it up. Does that sound better?
I hear
That's
everything. I hear everything you guys are doing. Not Facebook won't pick up everything, but I am constantly hearing an echo from all three of you, constantly, from
Really?
me picking you up. That doesn't mean Facebook will only hear some of that, but I'm hearing all of you at the same time, and it's just a constant echo. If you guys can get just one device where you can get it in your ear and put it behind you so you don't need something generating sound, what I'm picking up is like everything. Facebook won't pick it all up, but they will pick up some echo. If I'm hearing an echo in these phones, then everybody out there is hearing the echo, and I'm hearing an echo in these phones. So all the time throughout your whole broadcast, there is an echo coming from somewhere all the time. And the one way you get rid of that is to make sure you have some kind of device, something like this with a, if you have an iPhone, it comes with this microphone earbud combination, and that is the best. That's how I talk to people and listen to you at the same time. And some people won't hear it. It depends on their device, but all the time, you guys are broadcasting echoes because you're not wearing something like this. Because
I turn my sound down on that laptop, and I move the camera way over here, away from the sound.
If you can't hear anything, because I think that must be what you do, Kirk. If you can't really hear what other people are saying, then obviously nobody else can hear it. But then you can't hear what other people are saying. So for really good audio, because we're not Hollywood, we don't have these boom mics and stuff.
What?
I know, I'm sorry. I'm not quite there. I can't have boom mics on each and every one of you. If you guys can get some kind of earpiece so you can hear and not have to...
I would shoot my eye out, but I'll give it a shot.
It would help. It would help a lot for me and everybody at home.
I do have an earpiece. Let me go see if I can find it real quick.
I'm telling you.
Most of the time, when I'm not talking, I'm just listening and watching and learning myself. I usually just mute myself, so I don't even have an echo problem. But like when John's talking, there's definitely some echo there.
Well, it's interesting. You're the host of the show, and maybe you're not the Zoom host right now. I don't know if we figured that all out this time, but usually we do. Usually. Oh God, that's even worse. I don't know what you just did, but that's the worst ever.
Okay. Hey, I tried it. You're all witness. I tried it.
Yeah, but
I don't
anyway.
know. It's just something to watch out for. Because I noticed it when watching you guys before I got back, that there was oh boy, now what happened?
I'm doing the screen share thing. I'm done talking about this stuff. Just turn your mics off there if you're not talking, and try and keep your sound down.
Yeah,
I know it helps a lot.
But when just if you all, I don't know what you're doing, Kirk, to make it sound clearer, but maybe it's just because you have a newer system or something. I don't know, but
I turned the sound down on this laptop, and then I have my other laptop over here. My laptop. This is my cousin's. It's the only one strong enough to run the video stuff without glitching out. Sure. And then I have the cameras hooked to it, but I have the camera over here away from the sound.
Right. I'm just trying to get rid of the echo, because when I'm hearing you, Facebook picks up some of it, picks up some of the echo, but these headphones picks up all of it. And so it would be great.
Are you hearing an echo for me?
No, that's the thing, is I've never heard an echo for you, and you've never worn an earpiece. So I don't know what the trick is there.
Kind of an audio file, you know. Well, I understand that the microphone is going to pick up that sound, so you have to turn that sound down. Plus, I also went in and turned my mic down.
Right. There's certain things you can do.
Yeah.
But, you know, I just want to make sure that we've got a clear sound, and sometimes I can't make out what you guys are saying, because these phones on the broadcaster pick up everything, even if you're a little bit clear on one end. Like, I can hear that you're clear on Facebook.
Let's get on with the show here. So this is the Treatise on Arrests and False Imprisonment by Charles A. Wiseman. I actually have it on Kirk's Law Corner. I believe it is uploaded into Amber and Stephen as well. And some of you, my local peeps, it's in our group. So this is
also part of my paperwork.
This is a great thing to read and understand, because this is the law. I mean, everything is here. This whole freaking thing can just be printed out and used. This actually has documents in there to show you how to fill it out. Okay. This got the memorandum, points of authority. And one thing I like about this is crazy. It has an Idaho Supreme Court case in here. Which is, you know, kind of unheard of. I think it's it right. We got this one right here, number 8. Yep, number 8 right here. Imprisonment is any restraint of the personal liberty of another, and prevention of his movements from place to place, or his free action according to his own pleasure and will. It is false imprisonment when this is done without lawful authority. Okay, so the key word there is lawful authority. You'll hear me say lawful authority all the time. That is not lawful. That's not lawful. What that means is it's repugnant to the law itself. This stuff, this is the law. Right here, that Declaration of Independence, that is the law, okay? So we have to understand what the law actually is. That statute is not law. And I have case law on that. Statutes, codes, rules, and regulations are not law. And in fact, in this treatise on false imprisonment, and I'll get down to it, you cannot codify due process of law.
Hey, how are you? I'm all right.
Ted got his mics
on. You make it
on.
home okay?
Ted.
Oh, you're back home?
Oh, jeez.
Oh, good.
Here he goes again.
Well, that's good to hear. So what do you think? You had today off from school. You guys were traveling. You're home now. You have school tomorrow. Are you all set for school tomorrow?
There.
Not yet. What do you need to do to get all set?
You know, any restraint of your liberty is an arrest. So I don't know. How about traffic tickets when they pull you over? Okay, that is an arrest. Is that not depriving you of your liberty? Freedom of movement?
Right.
To go from place to
give
place.
Give me a brief about your weekend. Okay. What do you think?
They try to play this, weekend? Oh, well, you're speeding, or your tire touched the line. Whoopee! Who did I cause injury and harm to? Who has standing
anything in particular that you thought
because
was
if you don't have anybody,
pretty interesting.
You don't have a man, because suits have to be between man and man. You know, we don't do the inanimate object that doesn't exist. It's just a figment of the imagination against a man. Because how's that figment of the imagination going to get up on the stand and testify and say, yeah, that man over there caused injury and harm? It's literally impossible for an inanimate object that doesn't exist to get up on the stand and point a finger at a defendant and say, yeah, that man over there caused injury and harm to me. We call those, the Constitution of the United States of America calls that bills of attainder, and the Declaration of Independence calls it a declared act of tyranny. For depriving of us, in many cases, of the benefits of trial by jury. Try asking for a trial by jury in your traffic tickets. Well, you don't get one. Well, the law says I do if you're going to deprive me of my life, my liberty, or my property at any time. Okay? You have to have an injured party, and I have to have the right to a trial by jury. Why? Because no man can be deprived of their life, their liberty, or property without unanimous consent of 12 men of their vicinage, because that's what the law says.
Right, and face your accuser. Right?
Not statutes, not codes, not rules, not regulations.
Right, that's how we govern them, not them governing us.
Right.
There is a difference. So that's the conflict between social control versus domestic tranquility that I bitch about so much.
Right. It's I don't know. We've been so browbeaten and misinformed, miseducated, lied to, flat out lied to. Well, the statute says I have jurisdiction over here based on this statute. No. You need to go to the law. Okay? When you're talking about jurisdiction, you actually have to go to due process of law to find jurisdiction. Because this one here, the Constitution of the United States of America, that's the supreme due process of law. And, that legal maxim there, repugnant act cannot be brought into being. We go back to the law of nations there, the one I shared. Okay? No, the legislative branch cannot create legislation regarding the fundamental law. This is all fundamental law. And right here in the treaties on arrest and false imprisonment, you cannot codify due process of law.
And we can't pay him for that either. And what's that payment called, Kirk?
Well, is it an emolument?
or something.
An emolument.
Yeah, ish.
Oh, it's, yeah. And I mean, this right here, this treaties on arrest and false imprisonment, this is liberty. This is just the most basic thing, clear back to 1215 with the Magna Carta. The Magna Carta is the great charter of liberty from 1215. So what they were doing there in 1215 was actually the church, the people of the church wanted to separate from the Roman Catholic Church. Mm-hmm. They were trying to get away from that thumb of the Pope, acting arbitrarily and depriving people of their rights. Fundamentally, what we would consider in the Bible basic human rights, God-given rights, how to treat one another with Christian forbearance, love, and charity. That's our ideology here, laid down as the law in the Virginia Declaration of Rights, June 12, 1776. I didn't write it. That's in the law. That's how nations are created. You have to lay down the law by declarations. And we have those declarations. It's right here in my book, Annals of America. Right here, Volume 2, 1755 through 1783. Resistance and Revolution. That's where we're back to again. And what we're doing right here is we're trying to do the nonviolent, civilized revolution. We are, I don't know, how many years in society now, but we've kind of come to a somewhat of a civilized society since, I don't know, 600 AD maybe, somewhere in there. Okay? We should be able to sit down and go, this is just not something you should do to another man. Logic and reason, and discuss this, and come to a reasonable conclusion that this is wrong. Our founders laid it down as the law. So this is where I get into the term insane. any man of sound mind using logic and reason who can't come to a reasonable conclusion that what they're doing is wrong, you're insane. And I'll tell you to your face, you're insane if you can't quite understand the fundamental principles of law, core concepts of law. That is a repugnant act. After I show you the evidence, okay, you should, I mean, that's the thing is, in the Declaration of Independence, this is supposed to be self-evident. You can't do that to your fellow man. You can't
right. We have these truths to be self-evident. Yep.
Yeah.
You just took the words right out of my mouth.
And deprive him of his liberty without just cause. That's that probable cause they talk about in the Fourth Amendment. It's actually the fourth article of the Bill of Rights.
Right.
Okay. So right here, the law of the land, the authority to arrest without a warrant was rather limited and well defined at the common law, a law which has been made part of our constitutional law in the due process provisions. The common law rule on arrest is based on experience and common sense. Imagine that. Self-evident. As a general
common
law.
You didn't say common sense, did you?
No, I didn't. This guy did. I was reading as it is written, what it says. So this isn't my opinion. This is what it's written here. As a general rule of the common law, an arrest could not be made without a warrant. Imagine that. That's what the Fourth Amendment says. Thus, the right to arrest a person without a warrant is an exception to the general rule. Now, in just about everything that we have, there's always some sort of an exception to the general rule. Okay, there's usually an exception, right? But that exception, I mean, it has to be proved. That's the key. Okay. Thus, the right to arrest a person without a warrant is an exception to the general rule. The simple rule was expressed by Justice Carpenter in delivering an opinion for the Supreme Court of Michigan as follows. The law governing the case is elementary, except for a breach of the peace committed in his presence or when he has a reasonable ground to believe that the person arrested is a felon or is about to commit a felony. A police officer has no authority to arrest without a warrant. Y'all get that? Okay. The object in this law was to have a balance between preserving liberty and preserving the peace. Now we're going to get in over here to actually what breaches of the peace really are. It's not running your lawnmower around your yard or running your weed eater and your neighbor calls and says, hey man, that lawnmower is too loud. At 2 o'clock in the afternoon. That is not a breach of the peace.
Right.
The peace has to do with violence, domestic violence, and not the kind of domestic violence they call it today. What it's defined as today, domestic violence is between two men. That's domestic violence, or two women, or a man and a woman. It doesn't have to be a family thing. This is where they have misconstrued the law and a misapplication of the law and codified the law in a repugnant manner.
Oh, you mean stepped all over the Ninth Amendment?
Right.
Okay, just making sure.
By the people.
That's one.
Denied or disparaged.
Yeah, that one, the construed part. Right. Noted.
Okay. The object of the law is to have balance between preserving liberty. Okay. Those who committed the most heinous crimes, that being felonies, were a threat to the safety of society. Now, this is where they like to use that, well, this is for the security and safety of society that we created this. No. The security and safety of society is from domestic violence. And not the term that they use today. Okay. Could be summarily deprived of their liberty by arrest. Again, this is where we kind of have to understand arrest, and we'll get into that. Those committing a breach of the peace could also be summarily arrested, not for apprehension as a criminal, but to preserve the peace. But for other offenses, summary arrest had to yield to the liberty of the citizen. The liberty of citizens is too sacred to be left to the arbitrary will of men. Oops, wrong mouse. Okay, so everyone knows what felonies are. This is where you got to read this part here. This is page 11 out of 78. Actually, I'm on page 3 on this, but page 11 in the PDF. Everyone knows what felonies are. The most common felonies are murder. Imagine that. That involves violence. Rape. That involves violence. Kidnapping. That involves violence. Sodomy. That involves some sort of a violence there, right? Barnyard sodomy.
Yeah, ish.
Barnyard sodomy.
So something like that. That's 4.
Armed robbery.
There's 1.
Abortion.
Uh-oh. I'm running out of fingers.
Pedophilia. Treason and arson. So when we go to those executive order from March 1st, they're given the power of the people to arrest, because everybody's in the militia. Y'all know that, right? Every able-bodied, of course, some parts of it say every able-bodied male. But if you actually read the history, it's every able-bodied person, everybody. If you're 12 years old and you know how to pick up a rifle and shoot, that's what they did back then. Okay?
Yeah.
So now that we've listed what felonies are and what types of crimes are arrestable offenses without a warrant, okay, they're right there. The breach of the peace is also obvious and well known. Therefore, everyone's liberty was safe, since all knew for what reason they could or could not be arrested. Notice what they said. Well known. Was obvious and well known. That's the problem. It's not obvious and well known anymore, because nobody's teaching that, but it should be. Should be common sense. Therefore, everyone's liberty was safe, since all knew for what reasons they could or could not be arrested.
Right.
But when is the safety in one's liberty where is the safety in one's liberty if they are to be subject to every ordinance or law that here we go, legislative bodies may choose to enact? That's a question mark. Okay, this is a question. Or if the law on arrests can be changed by statutes. Ready for this? Okay. By the due process clause, the common law governs what the law on arrest is in this land. Law of the land, supreme law of the land, due process of law. They're synonymous. They mean the same thing. Okay. And where it exists, the most statutes can be is declaratory of the common law. If there is no direct language in the Constitution directing what procedure or process is to be followed, the common law is to be the due process of law followed, not a legislative statute or city ordinance. Officers who do not abide by this law are trespassers and are guilty of false imprisonment. Now, what's that one where man-made laws fail? The common law, it's the common, or the
when the laws of man fail, the laws of nature must be used.
Right. Okay, that's a legal maxim.
Yes,
so right here, we're reading it right now. Okay, and it goes to that law of nations again. The legislative branch does not have the power to codify, to change the fundamental law by statute. And here it is again, saying it again. And here's the thing. It is in here. It's the Fourth Amendment, or the fourth article of the Bill of Rights, and even in my own Idaho Constitution. Let's read that.
Right.
Oh, let's see. I think it's section 13.
But to get back what Kirk is saying, when you're talking about, and what John was saying earlier, when you're talking about where your authority comes from. So, for example, where's your standing? What's your basis for being in this room? That's the first element of jurisdiction. And what a lot of people overlook is that question. One of the things one of the reasons why the report I've created is so powerful, for lack of a better expression, is because it is based in, has its standing, is the Declaration of Independence itself. Remember, the original promise, right, from way back when we said, okay, England, we're done. You're fired, right? So we went back to just that point in time in our succession of law, as we've talked about it, and of course we went Virginia Declaration of Rights, the First Continental Congress, the Articles of Confederation, and of course the Constitution, and so on and so forth. But when I took it all the way back to the Declaration of Independence as the, in the table of authorities, right? That's the authority, not your statutes, codes, and rules and regulations. The authority is the Declaration itself. And in the Declaration, it says mock trials. Oh, guess what we're still suffering from? Mock trials. You think? And, it sounds so basic, it's almost stupid. And ironically enough, sometimes you just have to make it that basic because, again, once these things actually start becoming heard, and they are, even the congressional members say, well, you know what? My job in this seat, my inherited emolument, is dependent on what I do when I'm sitting here. Well, if I say this, and this, and they're reverse practicing it, doing this, and this, crap. Now what do I do? And that's kind of like where they are right now. It's not that they don't know, because they do know. They just are in the same conundrum and dealing with the same process that we are.
So the following is some material to help the citizen in protecting his liberty from unlawful encroachment by executive officers. CPS, we'll get to that. First, to initiate a suit against one who unlawfully deprives you of your liberty, there is an example of a summons and complaint. Right here, there's an example right here. We'll get to it. Which need to be served upon the defendant and the court. Okay, the defendant is the person who deprived you of your liberty. So make sure that when people come to your door, the first thing you get is identification, a business card. Technically they're required to have photo ID, a business card, and their oath of office. Did you know that? If you didn't know that, they're required to have that. You have the right to demand that from the public servant. Because if they're claiming some sort of authority, and I don't care what kind of disguise they're wearing, and I use the word disguise because that's what it says in Title 18, subsection 241. There's a 242. 242 is go out on the streets and highways in disguise. Okay? If they're in disguise, they're in disguise. That means that uniform. Uniform don't give you special powers. It's a disguise. Okay? We're all men and women here. Mankind. No, we're all created equal according to the Declaration of Independence, and no man is above another man. No man's above the law. I don't care what kind of disguise you're wearing. That doesn't give you special powers. Why is that thing? Okay, so here's the summons and complaint which need to be served upon the defendant and the court. There is also a memorandum of law on the subject of arrest without warrant, which is legal proof of the law that has existed for hundreds of years in this matter. On this matter. Now, these all have case law here. I mean, everything's right here. That is the full thing. So here's your forms. This is basically, it might be different in your state how this is laid out. But here, this is Minnesota. This is fairly close to how Idaho has it laid out. Idaho puts it up here in the state of Idaho District Court, whatever judicial district you're in. But this section here is all pretty much the same, just about anywhere. Some states lay it out, the plaintiff over here and the defendant over here, and then the file number down there. So pay attention to how your documents are in your state to file this, okay? And there it is. This is your title of your document, summons. So, and then it's to defendant above named, right there. You're the defendant. This is an actual case that went through, okay? This guy rocked these people. You are hereby summoned and required to serve upon the plaintiff an answer to the complaint, which is herewith served upon you within 20 days. I use 21. after service of this summons upon you, exclusive of the day of such service. If you fail to do so, okay, that's why it's exclusive of the such day of service. It's 21 days, including the day of service. This, it says 20 without including. Judgment by default will be taken against you for the relief requested in the complaint. We're getting to the common law here, folks. This is how you do it. This is the complaint. Okay, back to part of what John was talking about there earlier, how he lines all this stuff out. Here it is, right here. And you don't have to go to federal court for this. Okay, plaintiff for his complaint against defendant states and alleges. This is your statements of facts. Who, what, where, and when in each one of these statements. Okay, on September 30th, 1992, plaintiff was traveling his automobile on a public highway and called highway called between Ridgefield, Minneapolis, and going northbound when stopped by the defendant, acting as a highway patrolman and employee of the state of Minnesota. Okay, there it is. He's an employee. He's just a man. Okay, when you trespass the law, which we just read up there, you lose all immunity. That's Owen versus City of Independence. I don't care who you are and what disguise you're wearing. You're a man. You cannot trespass the law.
And he was acting,
right? You've been entrusted.
Patrolman, right?
Right. You've been entrusted to act lawfully.
Exactly.
I don't care what you're legally. Well, legally, I can do this. No, you can't. Because something that's unlawful cannot be made legal.
Correct. Which is a maxim of law.
Right. So we got hierarchy here. The law overstands any statute, code, rule, and regulation. And again, right there, as we just read, you cannot create a statute. The legislative branch has no power to codify due process of law. Due process of law comes from the law of the land or the supreme law of the land. And Article 6, Clause 2 says anything in the Constitution or laws of a state to the contrary or notwithstanding, which means hierarchy. That's why one's called the supreme law of the land and the other one's just the law of the land.
Correct.
Constitutions are law of the land. Everything must follow this process in order for it to be brought into being. The entire Constitution is due process of law. Okay. The defendant asked plaintiff to see his driver's license. The plaintiff explained that he is not a licensee under any board of commission and is not required to be a licensee. Oh boy. The defendant insisted the plaintiff must have said license. The defendant then arrested, searched, and handcuffed the plaintiff without warrant, and over his objections to the defendant's acts were in violation of plaintiff's rights and the constitutional provisions of due process of law. Imagine that. The defendant gave no specific charges to the plaintiff for his being stopped or for the arrest. Now, what I was talking about there in the beginning, I'll be honest, I didn't even read this. This is the first time I've actually read the complaint part. I've always zipped through it. So I didn't even realize this is about not even having a driver's license. But here it is, right here. Those traffic tickets they're talking about, they can't stop you. Papers, please. Papers, please.
Right. Sounds a little like Nazi Germany.
Right? The defendant gave no specific charges. Well, yeah, for being stopped for the arrest, because they'll say, well, you're under arrest for driving without privileges or failure to purchase the driver's license. No. What did you pull me over for? What is your articulable and reasonable suspicion that I did already commit a crime that has to be a felony that happened directly in front of you? Because you can't make an arrest without a warrant unless it's a felony or disturbing a breach of the peace, which gets into that violence. Okay. So two guys in a bar that's scuffling around. Okay. That's a breach of the peace. The guy mowing his yard at 2:00 in the afternoon or playing his stereo is not a breach of the peace. Because if that were the case, airplanes would be a breach of the peace all freaking day long. Fire trucks would be a breach of the peace all day long. Ambulances would be a breach of the peace. Harleys would be a breach of the peace. Crotch rockets would be a breach of the peace. Hot rods would be a breach of the peace.
Hey, now, don't be messing with my hot rods.
Semi-trucks, now here's, you get into that, okay, where the license is actually required by law is you're acting in commerce, okay? Semi-truck drivers, we want, for the necessary safety and security of the people that are traveling on the streets and highways, that 82,000-pound rig, we want to make sure that you know how to operate that machinery in such a manner as not to cause injury and harm to somebody else, okay?
And also that it is up to specification.
Right, subject to inspections, whether your tires are in good shape, your ball joints are in good shape, you know, you don't have any coolant leaks, so you're not spilling coolant on the floor, so the guy in the motorcycle behind you doesn't wipe out on antifreeze, spilling oil. I mean, there's an acceptable amount of, oh, it's just seeping, yeah, okay, it's dripping. But if you're dumping a gallon of oil a day in your truck in an 8-hour or 14-hour drive time, you might want to get that fixed. In fact, they'll tag it, and you'll have to have somebody come tow it to the shop and get it fixed. I know this because Class B commercial driver's license. So I drove a 10-wheeler. It was just a box truck, but it was registered for 82,000 pounds, and the most I ever carried was 64,000 pounds. It was a battery truck. So let me tell you, batteries are heavy, and yeah. So let's skip on down through this. This gives you the idea. This is in Kirk's Law Corner group, and it's also in Amber and Stephen. So now we get into the counts, okay? Now, this can work for everything. Okay, CPS worker came in, did all this stuff. Name them right here. These are your statements of facts, okay? False imprisonment. Plaintiff realleges paragraph 1 through 7. That's it, okay? On September, this is still count one, okay? Without warrant or due process of law, unlawfully seized my children without warrant. How about that? And did falsely imprison the plaintiff, depriving him of his liberty. You deprived me of my fundamental right by taking my child from me. That's what you would write there if that happened to you. If any man or woman comes to your door and seizes your children without a warrant, that is a deprivation of a fundamental liberty interest, clearly established by the United States Supreme Court, and pretty much every single state in the union already says, in Idaho, we go Idaho Code Title 32-1010. It specifically says parental rights are deeply rooted in our nation's history and are regarded as unalienable, or among the unalienable rights protected by the 9th Amendment. Okay, and then it even says due process of law in accordance with the 13th section of the first article of the Constitution of the state of Idaho. Okay, the statute's not the law. You can't codify the law. Due process of law has to come from here. And that's what it says in the code. Back to what it was saying there earlier, okay? They're codifying it, but they're telling you where to go for due process of law. But see, what I'm attacking right now is the fact that in that particular area, then it goes, oh, well, Title 16 or for domestic violence over there and Title 39. Now you're trying to codify due process of law. You can't do that. That's an usurpation of power, and it's repugnant to the law. Well, what is that in the Declaration of Independence for taking away our most charters or whatever? And that's exactly what this is. This is what they were talking about in 1776, the Declaration of Independence. That right there, creating these legislative acts. How about, he is combined with others to subject us to jurisdictions foreign to our Constitution and unacknowledged by our, see, that's why I go with foreign to our form of government, foreign to our law, and unacknowledged by our laws, given the assent to their acts as pretended legislation. That's a declared act of tyranny, what those social workers do when they come to your home without a warrant, okay? Not only that, obviously it's a deprivation of your right of personal liberty, to have control over your children, to go wherever you want to go. I mean, we just got to start hammering. We got to start standing up. We need to file this. I mean, this is pretty simple. And then, this could even be combined with the writ of habeas corpus.
Well, it's funny you bring that up. Brian just brought up an interesting point, and he says that we keep skirting around these two words of sovereign citizen. didn't skirt around those, Brian. You didn't read the paperwork, because on.
Do you see anywhere where it says sovereign citizen in there? I'm not going to bring it up.
Here's where I brought it up, and I brought it up in the complaint, but I wasn't talking about citizens individually. On page 25 of my actual tort claim, this was number 19. There is no greater attack on our sovereignty than assaults upon our courts by bad lawyers and bad case law. First sentence. So, to answer that question, no, I haven't. So, sovereignty was brought up in the complaint, and believe me, they know it. Also, to get further into that, there was a case in January of this year out of Arkansas, and you can Google search it. Just type up 2018 Arkansas repugnant, and I believe that'll pull up the case. I don't have it in front of me right now, but if you want to go look at that, Brian, I guarantee you the thing you're looking for, it might be right there. So just wanted to kind of throw that out there, because I'm trying to pay attention to comments as we're going here.
Yeah. So another thing I want to bring up here, this sovereign citizen stuff. Okay. I mean, I could possibly pull it up over here, but anyway, Idaho code, and this will be in every single state. Okay. As far as I know, I've found it in several different states. Idaho code, ethics and government, Title 74, subsection 201, the people of the state of Idaho, in creating the instruments of government that serve them, do not yield their sovereignty to the agency so created. Not my words, not my writing. That shit was written clear back in 1850 something. Okay. I didn't write it. Sovereignty is actually in the community, but I mean, there's stuff out there that says you're a sovereign individual. So
true.
I made a statement in my case that
can't hear you, John.
Can barely hear you, John.
Can you hear me better now?
Little bit. Mic closer.
Can you hear me now?
Hey, there he is.
My Tennessee.
Okay, you got to move your mic away from your speakers.
Something is going on with your whole setup, John. Like, no matter what you do, there's a ton of echo.
Really? So
I'm not getting it from Kirk or Chris. It's all coming from you.
Yeah,
Whether you have
no
the earbud
sound.
in or not.
I have no sound on my computer.
We're gonna have to do some kind of test.
Can you hear me better?
I can hear you, but the echo is insane. Now I can't hear you at all. What is up? Something's up with your system, bro.
Sorry, but an unknown error occurred while trying to play this video. Imagine that. On my phone. Let me see if I can. Jesus Christ, people stop.
See if I can get it working here.
So this is the memorandum of law on arrest without warrant. Okay, this is included in here. Right. I can hear your dude. The echo's coming from you, Ted.
No, it's not from me. I'm hearing an echo.
John is muted.
I know, but I'm still hearing an echo from that source. It's the strangest thing. That's why to rid us all of echoes, we all need to have some kind of earbud in. You know what I mean? Like if it's just you and me, Kirk, we'd never hear it. It wouldn't be an issue. Even with two people.
We've been doing good with just we gotta figure out something on John's end. I don't know if
that is weird.
Sometimes it does, sometimes it doesn't. Anyway, Memorandum of law on arrest without warrant. So this is a memorandum of law right here. Okay, it's already right here. Okay, so like I said, this can be printed out and used. Okay, that's supposed to be this information right here. You will have to, this will, put your name in there. A free citizen of the state of whatever, who respectfully presents and submits this memorandum and evidence and proof of the prevailing and controlling law regarding the matter known before the court. Now, there's several things that you can add or take away from this in your own paperwork. Okay. But this is pretty short and sweet here, right? Okay. Page 1 of 13. This is the part that you'll need to do. But here is, all of this is the memorandum. See, page 2 of 13. This is all the memorandum. This is the part that you need to do right here. And then, come on. See, there's the law right there. So basically everything from here up. I mean, that's it. This is your little statement. You've already made all your statements of facts up here. Okay, and your accounts, what you're charging them with. That's basically what it is. See, here's $10,000 for that one. Assault and battery. This is all he's asking for is $10,000 together with a cop. And this is just for the simple pulling him over. $10,000. And that's true. But things have changed a little bit, and the federal code says something a little different now. For a felony, because that is a felony, that's $250,000. I went from $10,000 to $250,000 from 1993 to now. So, deprivation is of right while acting under color of law. Well, the law says no. Your statute or your policy says your statute. Because that ain't my statute. That stuff don't.
That's my favorite example. Walmart employee walks into Target and tells the Target team member, he has to follow Walmart policy. Yeah, sure he does.
Right? And see, let me look at this. The Constitution of Minnesota declares that no person shall be deprived of life, liberty, or property without due process of law. Well, let's see. What does my first one say here? Inalienable rights of man. All men are by nature free and equal and have certain inalienable rights, among which are enjoying and defending, this is a right, life and liberty, acquiring, possessing, and protecting property, pursuing happiness and securing safety. Imagine that. I don't know where it talks about. Oh, I think it's that 13th section. It's got to be. Guarantees in criminal actions and due process of due process of law. In all criminal prosecutions, the party accused shall have the right to a speedy and public trial, to have the process of the court to compel the attendance of witnesses in his behalf, and to appear and defend in person and with counsel. It doesn't say attorney. It says with counsel. No person shall be twice put in jeopardy for the same offense, nor be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. There it is, right there.
And notice what you just said.
Code references in Title 32-1010 that says due process of law. If you're going to deprive this fundamental right, okay, protected by this is an unalienable right. Where do we have unalienable rights? From the law of nature declared in the Declaration of Independence, and protected by the 9th Amendment. Okay, must follow due process of law. What I just read right there.
Right. So when you're talking about that due process of having assistance of counsel and presenting evidence, et cetera, the on his behalf part is very key right there. Right?
Mm-hmm.
Go back to where you were talking about, where it said present the evidence and arguments in his behalf.
Right. The attendance of witnesses in his behalf.
Mm-hmm. Right.
So I have the right to call my witnesses to the stand, and you cannot deprive me of that right. It is a fundamental right. Fundamental. These are fundamental principles of law. When you're talking the bill, these are bills of rights. I'll go right back to American Jurisprudence, Volume 16, subsection, it's constitutional law, subsection 100, that bills of rights are merely declaratory of the common law. We just read that right there, too. It's in American Jurisprudence. It's right here. I mean, there's case law that's up there. There's all sorts of it. So, right here, in interpreting what due process of law is, it has been held that none of our liberties are to be taken away except in accordance with established principles. Established. Okay, we have to understand that word. Okay, here we go. Preamble to the Constitution of the State of Idaho. Okay, we the people of the state of Idaho, grateful to Almighty God for our freedom to secure its blessings and promote our common welfare, do establish this Constitution. Okay, statutes are created by bills and become a congressional act. They're not established. Constitutions are established. The supreme law is ordained and established. And the Declaration of Independence is the law. The constitutions are the process of bringing things into being from the law. For the protection of our rights as the law, that's what we instituted government for. Okay? So there's lots of great information in here. It's only this 78 pages, okay? Great stuff in here. Now there's things like this one here, Idaho Rules Professional Code of Conduct, all right? So let's say that officer out there violated the law, right? Okay, guess what else you could put in there? Let's go over here to Rule 4, or it was a 1.6. Right here, this is number 5, I think it's 1. This is the preamble, okay. Preamble, the lawyer's conduct should conform to the requirements of the law, both in professional service to clients and to the lawyer's business and personal affairs. Personal affairs, imagine that. Professional code of conduct here.
Right.
A lawyer should use the law's procedures only for legitimate purposes and not to harass or intimidate others. A lawyer should demonstrate respect for the legal system and for those who serve it, including judges, other lawyers, and public officials. But not anybody else, huh?
Right.
What it is, while it is a lawyer's duty, when necessary, to challenge the rectitude of official action, it is also a lawyer's duty to uphold legal process.
Well, which also goes to there's two documents, and they're in the paperwork. I know you've got them. The first one is the sanctions imposed on attorneys who abuse the judicial process, right? That's the fault of the practitioner. It's not the fault of the court. It's not the fault of the judge. It's the person who wrote the document, right? Mm-hmm. Period. Squarely on their shoulders. Yeah. So now, if that becomes a factor in your case and your counsel does not point that out, that's where the other ineffective assistance of counsel document becomes relevant. Because those two actions right there, think of it as I always try to explain it this way. When you're talking about physics, for every action, there's an equal and opposite reaction, right? So when you talk about law, the action being the vexatious litigation, without a reaction, right, you've got such a momentum of force going against you without any kind of a defense. I mean, and yes, it seems very, very stupid simple, but that's exactly what's going on. And I mean exactly what's going on.
Right.
So
here's some terminology for you. This is in the Idaho Rules of Professional Conduct. Tribunal denotes a court, an arbiter in a binding arbitration proceeding, or a legislative body. Administrative agency or other body acting in an adjudicative capacity. A legislative body, administrative agency, or other body acts in an adjudicative capacity when a neutral officer, after the presentation of evidence or legal argument by a party or parties, will render a binding legal judgment directly affecting parties' interest in a particular matter. Tribunals are military tribunals. That's admiralty jurisdiction. We are not supposed to have those inside the borders of a state.
Nope. And that's exactly what's happening.
And that's
how they're usurping the law. Remember?
Yep.
When a long train of abuses,
usurpations,
right?
This is a guidance document.
Right. So that's what I said. You know, that's when I drew the science out for them, and I said, here's how they're usurping the law by subverting the process. The law is right here in the middle. They're not even connected to it. And that's literally how they're literally going right around it. And every one of those loops in that process is designed to go right around the law, right around it.
Right. So we go right back up here to D under terms. Fraud or fraudulent denotes conduct, this tribunal. Okay, that would be conduct.
Yeah.
That is fraudulent under the substantive or procedural law of the applicable jurisdiction and has a purpose to deceive. We are being deceived that these tribunals actually have the authority to act and inside the borders of the state. And this conduct is repugnant to the law inside the borders of the state. So it means that's fraudulent. It's fraud. Okay. So I want to jump down here. I think it's in section 5. There it is. I think this is rule 1. Finally getting into rule 1. Oh, yeah, this is still in the terminology. Where it denotes fraud. Okay. When used in these rules, the terms fraud or fraudulent refer to conduct that is characterized as such under the substantive and procedural law of the applicable jurisdiction as a purpose to deceive. This does not include merely negligent misrepresentations or negligent failure to apprise another of relevant information. This does not include merely negligent. Anyway, for purpose of these rules, it's not necessary that anyone has suffered damages or relied on the misrepresentation or failure to inform. Okay, here's that informed consent one that I was telling you about. And I want to get down here to
Well, and then there's another thing and he just scrolled right by it, where it talks about informed consent. Okay.
Yeah, I know. That's the one I was telling you about. They entered that stipulation on my behalf without my consent.
Exactly. So when you're talking about that, okay, while you're scrolling, I'm gonna touch on that real fast.
I gotta go down forward.
When you're talking about informed consent, okay, in other words, your attorney has taken and applied you as a person to this process, which is repugnant to the law, by the way, but later we'll do that. But they did that without duly informed consenting or duly informing you.
Yep.
To where you would have the ability to either deny or accept, right? They just say, oh, just sign here. And they don't tell you what they're doing. Okay? That is right where I go back to the sanctions imposed on attorneys for abuse of process, right? That is also them scamming you. Oh, just sign here and we'll take care of it. No, I'm not signing anywhere. I'm not consenting to you attorning my life. Who the hell do you think you are? What's your standing to do this? And see, when I came up and I asked that question, so I could care less about the jurisdiction. If Congress says family court is where it is, then that's where it is. The simple fact of the matter is I want to know what your standing is.
Yep.
To bring forth this action. What is it? Under these rules that I don't consent to.
Okay.
And that was what shut them right down. I mean, it was just that simple.
Check this one out. Crime by the client. So your attorney's representing someone. An attorney is representing someone. Under Rule 1.2d, a lawyer is prohibited from counseling or assisting a client in conduct that the lawyer knows is criminal. Paragraph B states a specific application of the principle set forth in Rule 1.2d, which I just read up there earlier, and addresses the situation where a client's crime takes the form of a lie or misrepresentation. Okay, ordinarily a lawyer can avoid assisting a client's crime by withdrawing from the representation. Okay, get into your rules of professional code of conduct. Contempt of court, right? Contempt of court is a crime, is it not? Sure is. Okay, lying, perjury, that's a crime. So anytime that somebody on the other side, I don't care who it is, whether you're in family court, criminal court, whatever court, even the prosecuting attorney. Prosecuting attorney is bound by these terms and conditions of their contract, right? Okay. So if you're in a criminal case, which again, I highly recommend that you represent yourself, sui juris, and right there, well, you're committing a crime. Your client, Mr. Prosecutor, has committed a crime. Well, I don't have a client. Well, sure you do. You're representing the state of Idaho, aren't you not? That's a crime in and of itself. You're listed down there on Dun and Bradstreet. Can't incorporate anything. You can't be a corporation. That's a corporate Ponzi scheme. But realistically speaking, let's get back to what I'm actually talking about there. I kind of went off the tangent. You know, if the other side, even the prosecuting attorney, bring in somebody, you know, we invoke the clean hands doctrine here. You know, you can't lie. So that's a crime. Perjury is a crime. So if you're a prosecutor or just you're in a civil situation or family situation, it doesn't matter. You can put them on notice that their client is committing a crime, and under pursuant to this rule, Idaho, see right there, IRCP, that's how you quote things. You have to quote what it is. Idaho Rules of Professional Code of Conduct, okay? Rule 4.13, and this you have to itemize it exactly as it is written, so they know exactly. Why does this say 3.9? I thought it was 4.1. It is, right. Pursuant to Rule 4.13. And then under Rule 1.2d, exactly how it's written there. So we can go back up to Rule 1.2d, and you just apply them both together and say, okay, you know, in your, like I have done in my affirmative defenses and counterclaims, that I put that in there. So when he gets that, it's going to be like, oh, crap. Yeah, you're right. She is committing a crime. I can't represent you. I have to withdraw. By his own rules of professional code of conduct, he's out of there.
Well, and that goes back to standing. Chad asked to explain standing. So I'm gonna read you from the big book their definition of standing. And this was established in 1924. A party's right to make a legal claim or seek judicial enforcement of a duty or right. To have standing in federal court, a plaintiff must show, number one, that the challenged conduct has caused the plaintiff actual injury, and two, that the interest sought to be protected is within the zone of interests meant to be regulated by the statutory or constitutional guarantee in question. So,
yes,
when you're talking,
cause of action, you have to have a right that has been trespassed. The law has to be trespassed. The law is your right. The injured party, the corpus delicti, okay? If you don't have the corpus delicti, there is no standing in court. Nobody has any standing if you don't have a corpus delicti. Period.
Right.
Somebody
And
has to claim
standing
the
is
right to a
actually
cause of action.
expanded. Right. Standing is actually expanded goes from page 1625 to, let's see here.
So, like the traffic ticket, okay? A motion to dismiss with prejudice for lack of jurisdiction for failure to state a cause of action for which relief can be granted. Because you
Right.
can't grant nobody relief that nobody exists, to nobody who exists. If there's nobody over there withstanding to claim their right to a cause of action, the court can't grant relief to somebody who doesn't exist. I mean, that's just common sense to me.
Oh, be careful about those words common. My granddad always used to say,
so
be careful with the word common sense, because what's common to you might not be common to somebody else.
See, here's one that we discussed before the show started that we would discuss at the end of the show. And that is slander and libel. Okay. You have the right to freedom of speech. Okay. Like all other rights, you have a duty here to respect other people's rights. Okay. So one part of your duty and responsibilities in exercising your right to freedom of speech is you cannot slander someone else, which means like that guy over there is a drug addict. That guy over there does this, or that guy over there does that. Oh, look, here's this. I think that they did it. Okay, you better check into what you're doing before you start doing that, because if you make a false statement, that could be very bad for you. Very bad for you.
Yep.
And even if it's true, if you're using it in a manner to disparage someone and their rights, like, hey, whatever. I don't know. I can't even think of an example right off the top of my head. But
I could think of one.
You deny and disparage, all right? If you're using that information, say you go on to the court reporters, whatever it is in your state, however they call it, repository, I-court, what we call it here in Idaho, repository and I-court, and you look up somebody's record, you better make sure that it wasn't dismissed. Because if you start slamming them out there, well, look, he did this, and he did this, and he did this, and you didn't check to see if it was dismissed, that's called branding. The whole thing is branding to begin with. But you use that against somebody, or you make that false statement out there. It may be true that they were charged with that, but you better make sure that they didn't go to trial and was acquitted, or it was dismissed before trial.
So let me ask you this, my friend.
Sure.
If somebody accused me of child abuse, and I was never even charged with child abuse, what can I do?
Well, let's look up the word disparagement. Okay? Comes from the 16th century.
All right.
A derogatory comparison of one thing with another. The disparagement consisted in the comparing the acknowledged liar to a murderer. Okay, that's the first one. The second one, the act or an instance of unfairly, let's see. Light in here is pitiful. Okay. The act or instance of unfairly casting or detracting from the reputation of someone or something when she told the press the details of her husband's philandering, her statements amounted to disparagement, is an example of that. So basically what that means in lay terms is if somebody says something against you with the intention of doing you harm or to diminish you as a person in the light or in the minds of other people, that's a crime. That is slander by definition.
So
okay?
if this fringe group called Op Exposed CPS or Kara Zimmerman or her bearded
We don't
lady
like
friends.
these names now. No names. No names.
Yeah.
Well, you know who I'm talking about. If these scumbags are calling me a child abuser, then I have a case.
Well, technically speaking, yes. Now, you have to be careful because until you prove your case in court, yes, it is reasonable that you would come out swinging against somebody who makes a false statement against you, as normal people would. But such remarks can also be used against you when you go into court and say, you know, this is what happened on this day, blah, blah, blah. Of course, other side attorney is going to do his or her homework if they're worth their salt in any manner.
I mean, I'm not a child abuser. I've never abused children. So somebody saying I'm a child abuser could...
Welcome to the club, brother. Mine's unsubstantiated. It only took them 10 years to come up with it, but they finally came up with it. So, you know, not only was it dismissed in the beginning and was I never arrested and all of that other happy, unlawful attornment crap.
But this was never anything that came up. This. Oh, all right. So we're back in this scene. Let me get us back to the regular scene. So I'm not. I've never been accused as such. Ever in the history of my life, have I ever been accused of anything remotely involved in child abuse. And so just because of this event, trying to get the cameras back, just because of this event...
I had locked. I bet John's been trying to get back in.
Hold on. Trying to get this camera going. So, with somebody accusing me out of the blue with no evidence of me being a child abuser, what?
I mean, that's straight up slander, defamation of character.
Yeah.
That's what it is.
That's right.
Well, that's the second time my phone is shut off on the video.
That is an actual disparagement, correct?
So, somebody like...
well, it's defamation.
Alright, there we go. So I can bring us all back.
Is that John coming back?
No, that's me, but it's John's not with us, so it's just the regular blue camera. So now we see we see Chris in a blue screen. So this is the first time anybody has accused me of a crime that I haven't committed. I know where it's coming from. I know who's doing it. It's
the damage is the defamation. Leslie's like, oh, you gotta have if the damage you then you have if there is damage to you. Well, of course it's damage to you. You know what Ted does out there?
I try to help everybody. I don't care who
He does a lot of work for a lot of different people out there, and you make that kind of statement about somebody. You know what kind of things that can do to him? How many people want to work with him now and talk crap about him? You know, that's called punitive damages.
Yep. And Jessica brings up an interesting point. When officers of the court do this, technically speaking, an officer of the court is always under oath, right? Always.
Right. Always.
That's their oath of office. Right. So that's why I said that's kind of where we ultimately end up. She kind of jumped ahead of us a little bit, but she brings up the interesting point. If it's bad enough to where when it's a person versus person, okay, and it does that kind of damage, now we're talking about officers of the court. Now, in my own particular case, it was the person that I paid to represent me.
Right. Not only is that embezzlement, but it's defamation of character because you've lied.
Imagine that.
It's perjury, it's embezzlement, which is an emolument, and it's defamation of character because you lied.
Correct.
And it caused you to lose your child or lose your whatever.
Right. So in this situation,
that would be the damages in that situation.
In this situation, what I do every day is lose everything I have for this community. I lose every day. Everything I spend is lost. Every moment I spend in this community is lost. So when I move a little bit forward and I get in touch with John Schaefer, for instance, the Nancy Schaefer's son, and then all of a sudden, out of the blue, according to Op Exposed CPS, Kara Zimmerman, and the bearded lady, I'm a child abuser, out of the freaking blue.
Okay, so this is what we need to understand here, Ted. We can't. We can't do that. And that's exactly, John's right here. There are two forms of defamation, libel and slander. You can't say people's names and talk about them. If you're going to do that, you got to go to court and do that under oath, under penalty of perjury, or it's a crime.
So, Kara Zimmerman slandering my name.
Yeah. No.
So, without 100% proof who is saying it, even though I know the area.
Right. So,
I know who
this is where we try to keep things general and not to use any names.
Okay.
Because, like you said, you don't actually know.
Right. So
not 100%.
You don't have the solid evidence right in front of you going, yep, that's the person who did it.
No,
and then you got to be able to prove, like when you're talking around out here on Facebook, you got to be able to prove that their account wasn't hacked, that it was actually them behind the computer. They didn't walk away from their computer and left it on at work, and somebody came by and went, "Oh, this guy's a jerkwad."
So you're saying that if somebody, Kirk, if somebody calls you a child abuser out of the blue, that you have no recourse?
No, what I'm saying is you have to have the evidence before you go saying names, dropping names. You got to have the evidence that it was actually them.
And how do you get that if it's just off of Facebook?
Like I was just saying, you'll have to have that evidence. So on Facebook, these are the things that their attorneys are being passed around with each other is, oh, go onto their Facebook stuff and see what you can find. And, I have proof in my own case where they went in and pulled some stuff off of my Facebook page. And it's funny now that nobody wants to pull anything off my Facebook page anymore. I don't understand.
Well,
so
I do have a couple of accounts.
Go find where it's at and screenshot it.
Right.
I mean, that's it.
Yeah, because there
Once
will be
you got that evidence, then it's like, here's the evidence. There it is. There's a screenshot. That's that person's name, and that's what it is.
And one of the key things is the date, right?
Yes.
When did that happen, right? So if you can show the date and where it came from, you now have basically established a crime scene, right? And you follow the investigative process to show that, action A led to action B, led to action C, and so on and so forth. And like John said, John Patton said, brings up an interesting point. There's 3 prongs to a defamation. So you got to make sure you hit all 3 of them.
Mm-hmm.
So
the who, what, where, and when, how it was done.
That's right.
So I'm pretty sure with your guys' help, I mean, the one thing that kind of blocks you from getting all that information is whether they block you or not. So if you have a few friends who can confirm all of that, then your case is 100%. So
right.
Really, if somebody blocks you from Facebook, all you need is a couple of people like you,
right,
Kirk, and you, Chris, to corroborate that, and you're all set.
Right. As a matter of fact, and it can come back to really bite somebody real hard. ironically, I'm going through this right now. There's a certain somebody out there going around basically proving how hard I tried to work to get this person through the problem. It is pretty much exactly what these screenshots floating around show. So,
Ted, remember the guy?
Thanks for pointing that out.
From BJ? I'm not going to say her name, but you know who I'm talking about.
BJ.
BRE? Brad. She had a guy that was even on my own stuff, just, oh, you don't know what you're talking about. I'm going to sue the crap out of you. You're going to jail tomorrow or whatever.
So come on.
But
bring it.
But what's it been, 2-3 months now? 2 months, at least 3 months. You know, that's the thing. People, you making idle threats to somebody who actually knows the law, you're screwed.
Well, all I had to do was just show them this.
I'll try and make amends. I mean, I'm not perfect. I'm a human being just like the rest of you out there.
Yeah, that's the Florida Department of State that did this. I didn't do this. The Florida Department of State did that. Right. So,
I don't have mine.
Yeah.
I have mine, but I don't have it right here.
Right. So, I mean, it's like, okay, you don't know. Well, apparently the Department of State says and thinks I do. So, if they're willing to, yes, here, we want you to do this job, then guess what? I'm going to do that job.
So, I'm just curious. I mean, my limited amount of common sense that I have, with that letter of an unsubstantiated claim, doesn't that mean that somebody lied? That would be a false claim. Wouldn't that be perjury? And if you used that perjury, I don't know, to deprive someone of a fundamental liberty interest, such as a child, that's like prison time, right?
Right. Well, also, in my particular case, it's double duty because the orders say, which is the ones they've strategically hidden, by the way, that I've always had custody of the kids. I do have the child support order, right? So when it comes to, well, how did you get a child support order if you don't have custody? What would a reasonable person conclude about that? It was a pretty much a no-brainer, right? So, now we're going, that's why I said, now that the truth is coming out, it only took them 10 years. It's like, oh, so wait a minute. The worst thing Dad did was he got up in the morning, went to work, put Mom through 4 years of college, took the kids to school, did all their activities, including laundry, and helped around the house and all that. And your problem was what? And that's, believe it or not, that's the reaction I get when this comes up in court. I've said to him, I was like, look, I'm done talking about it. I don't even want to talk about it anymore. I'm done with that.
Right.
That's called moving on.
It's called unfriend, unfollow, block. On to the next person.
That's right.
On to my own thing. I mean, those of you that actually know me have known me long enough, especially in Facebook land here, but even in reality, I've said, look, I don't want to have communications with you no more. Don't call me, don't text me, don't come by my shop, or don't come by my home. That's who I am in real life. You mess around with me, and you disrespect me or something, you're gone. You're out of here.
Right.
I'll give you the chance to make amends, because I know that everybody is human, okay? But if you blatantly screw me over and not, how do I say this? Negativity is my big thing. Lying and stealing. Most people can agree with that, right? Don't steal from me. Don't lie to me.
You would imagine people could agree with that.
Don't lie. Don't steal from me. If you make a mistake, even if it's, again, back to that little white lie, do these pants make my butt look fat? There's a difference. If you're lying to me about something that's, kind of important in life, you got to go.
Yeah. Yeah, in my case, it's not my pants that make my butt look fat. It's my butt that makes my butt look fat.
Yeah. Maybe you shouldn't wear pants.
Yeah.
All right, folks. We are after the hour. You know, some nights we could sit here and go for 4 hours, which we have.
Yes, we have.
I'm hungry. I need to go eat. So,
amen.
Thanks for tuning in tonight, folks. Sorry, John. We got to figure that echo thing out. Maybe we can get you back on here real quick.
Right.
And
we'll have it worked out by Wednesday's show. So, and
much love. Much love, everybody, for tuning in. Share, like, and share.
Yep.
We're almost at 1,000, I think. 1,000 likes. And we're over 1,000 followers, which is weird. So.
Yeah. And don't forget to tune in to our brothers and sisters over at our other shows. We've got Far From Normal tomorrow. We'll be back with you on Wednesday. We've got Sundays and Thursdays, Restoring Families Internet Radio. We had somebody on Fridays. I believe we also have Amelia Duran in Portal to Justice. She does shows regularly. She doesn't actually have a set schedule, so keep your eye on Portal to Justice, because when she has a guest, she just brings them right on. Gotta love Amelia. She just right out there with it. So
nice.
Love her to death. And on that note, we will see you guys on Wednesday.
Thank you, Ted, for producing our stuff out here, getting it out there to the people.
You're so welcome.
Are you broadcasting to the new YouTube channel?
Yeah, Kirk's Law Corner has a YouTube channel, which we are broadcasting to.
Awesome.
And if you want me to help you broadcast, I can broadcast to multiple channels. Twitter, Facebook, YouTube, or not Facebook, sorry, because that's a custom RTMP, which costs $150. So if you'd like to broadcast on a page and your profile, that's $150 plus $150
per year.
Per year, yeah. We're working on Instagram and Google Plus. Each one of those, $150 a year each. I'll probably end up doing that myself, but I could use some help. Everything I do is going to end in about a month, unless I can get help from you, Chris, and Kirk. My subscription is gone. I have no money to keep this going. I'm pretty much at...
Maybe we can put it out there to our folks. Make a small donation, $1 here or $1 there. We come up with $150. That pays us for Ted Fogg for a year.
Yeah, maybe.
Can we do that, folks out there? Can we scramble up $150 so Ted can continue producing our show? And
I can reach in. I can pull it. I might be able to pull up some Knish for that. We'll get together on that, Ted. See if I can get that.
I've been looking at GoFundMe's for the last 2 years.
Mm-hmm. We could set the GoFundMe right at $150, whatever exactly you need, and so it gets donated directly to that. And
well, what I could do is I'll just run it through the business. I'll run it through the business account.
Or just call me a child abuser, and I won't have anything to do with fucking anything. Fuck you guys.
Hey, I noticed John just came on. I want to jump back in the meeting here. We'll do an after-show meeting, see if we can't figure this microphone thing out.
Yep.
We should do that. But let me tell you guys something. I didn't know what love was until my son was born. You all know that. You guys know that. For someone to call me a fucking child abuser, I just said the F word, sorry. It doesn't matter if you push me out of if any movement, doesn't matter.
I know.
I think everybody out there feels exactly what you're saying, Ted. Every one of us.
Yep.
There is a person, two people out there, Kara Zimmerman, Lisa Rutherford, those two fucking piece of shit scumbags.
Hey, now, easy.
We can't do that.
Those are the people who called me that.
So,
you see?
Yeah, we've got to be nice.
But I'm not nice about that.
I know it's hard, man. Believe me.
It is hard.
If you're gonna call me,
I can tell you,
if you're gonna call me a child abuser, no, hold on. Hold on, Chris. If you're gonna call me a child abuser,
this is Facebook fairyland out there. You know, all of this that we're doing right here. This is real stuff.
Something's going to come back on you.
If you meet me in person, those are my friends that have met me locally. Probably attest to this. This is pretty much who I am. You know.
Yeah.
And the funny part is most of the time when I get up in the morning, I'm the same guy as I am right now.
Yep.
Right.
Very rarely do I have any kind of like weird mood changes or, you know. I mean, I guess I smack my hand with my thumb with a hammer. There's going to be a little bit of a mood swing there for a minute.
Nobody
just a little bit.
Corner of the coffee table or the corner of the bed or.
Nobody deserves that.
As you invent a couple of new swear words.
Right?
Yeah. Laid down, ordained, and established.
Nobody deserves that.
No, they don't. But again, back in the Facebook land, dude, unfriend, unfollow, and block.
Exactly.
Get it out of your mind. Forget it. Move on. Keep your focus on what you're doing. That is a distraction by design. You know, again, we go back to having to understand that these, even myself, we've been through it. Okay, I've been through it now. I haven't seen my son since January 20th was the last time I saw him. Short time for some of you people, but you know, they've been traumatized. Some people don't have the mental strength that I have because of the shit that I've been through in my life. I am mentally strong. I can look at it for what it is and go, yeah, I really miss my son. I can feel it right now in my heart. Yes, I miss my son. And I know that my son misses me because of our relationship. And I know that he loves me. Yeah. We have fun together. I don't abuse my son. And in fact, they're being unsubstantiated. And I'm kicking their butt in court and they know it.
Yeah.
They walk out of there with their heads held down. We still got my turn. It's my turn when we go back to court. Well, you got your turn. My turn.
I got grandbabies out there, guys. Believe me, I don't talk about them much because it's even worse than with the kids. But you know, I got 3 grandbabies out there, two little boys and a little girl. So believe me, I get exactly what you're saying and why you're saying it. And to let it go is, at first it's difficult, but then when you realize it's like, well, you go back through and you think about it and say, would this have happened had these repugnant processes not existed? No. So there's a very good possibility that it wasn't entirely your ex, because remember, we've been lied to. You can be bet dollars to donuts as sure as this chair I'm sitting on, which is my emolument, by the way. Bought it myself. He or she was lied to as well. Just know it, accept it, and that will help you start moving on.
That rules of professional code of conduct, whether the attorneys aren't supposed to represent somebody when they're committing a crime. Perjury is a crime.
Something like that.
That's kind of what you've talked about before too. You know, even Crystal, Bill's, Maelstrom, protected her ex-husband. Okay.
Right.
This is how that's an emolument. She is paying, or he paid his attorney to attorn her unlawfully. He shouldn't have done that.
Well, then to add insult to injury, in that federal case, when this is all said and done, and I'm sure she'll bring the audio on so you guys can hear it. But when she actually defended her ex on that and pointed out the integrity issue of the actor, in that case it was that attorney, pointed that out, that this person was paid he paid this person to represent himself. He wasn't there, but the whole time this guy standing there and talking about how wonderful he was, didn't say not one word about his client. Mom had to step in and do that. And I can tell you right now, that was one of the key issues as to how we got the orders that we got and the direction that we got in that case. Because it wasn't just what we used here, it was what came from in here. And the judge saw it. So I can tell you, your actions speak louder than your words.
I have an idea.
Yes.
I have a really good idea how to kind of put us all in the same general group, you know? Oh, there goes the music again. But, boom. You know, we're all doing this, and if somebody comes after you for no reason, Chris, I know you understand that. Kirk, you understand that. Just out of the blue, somebody comes after you.
Called psychopathology.
And so, what if we have something based around not necessarily the 13 circuits, but the 11 circuits, because there's only 11 federal circuits within the continental U.S. I have an idea, and based on what I know from the organization known as Restoring Freedom, the organization known as the Father's Rights Movement, there's a lot of examples of how we can organize ourselves to protect ourselves from lunatics. And so when I come back from Georgia,
it's unfriend, unfollow, block. Move on with your life. That's it. That's the 3 steps.
I have an even better example. Because what we need to do is get support from lobbyists. Get support.
No, I'm telling you right now, short and sweet. Those 3 steps and walk away.
Yeah.
We're talking about individual person. Again.
Well, no, I understand what you're talking about, but I'm talking about moving ahead.
Oh, okay.
Well, yeah. Basically, you're talking about the congressional process. So, the thing you might want to do is send just sit down with your congressional rules. Pick a committee, okay? Read their rules, and just type up a general petition. There's many examples out there for a template. It doesn't have to be long. It doesn't have to go into a whole lot of detail. You can be a couple, 2-3 pages. Just seeking an audience under whatever the rule is in your state.
Yep.
And just to have a sit-down meeting with them, give them an itinerary, pick just a couple issues, right? Bullet points. Yep. Give them the copy of that so they're prepared for the meeting when they get there. And just talk about those things. They will talk.
All I want to do is make sure we are moving ahead in the same direction.
Yeah.
I have an idea. I'll work
that's the whole direction I've been trying to go for at least the last year and a half, almost 2 years now.
Yeah. Right. Well, when you get some scumbag calling you a child abuser, Kirk.
Yeah. Well,
what do you think I'm going through right now?
What's that?
I said, what do you think I'm going through right now?
We've all gone through that.
Yeah. I never have. Never. My My ex-wife never called me that. This is from a fringe group. I think we all known as Op-Exposed CPS.
So you're talking about out here in Facebook land, and I'm actually having to go to court and being deprived of my son.
No, well, I'm not going to let anybody, Facebook or anybody, fucking call me a child abuser. I'm going after you.
But look, Ted. Do you see how I'm acting?
Doesn't matter. Let them talk their shit.
Yeah.
Because in the end, the truth comes out, bro.
Bingo.
Every time.
Well, no, I know that. I don't care what people say, but but
you do.
I will go.
Yes, you do.
Not individual, but I will go after a group. Is there a difference between a group or a person?
So I'll tell you what. If somebody comes to you with a concern about that, you give them references and say, look, here, why don't you talk to some people who actually know me? Or why don't you go look at the record and see if I'm actually even charged with that?
Well,
so what
I never was.
I always tell you. Ask a mom. Go, look. Danielle just nailed it. She said, they want you to react.
Yes.
Well, of course. Well, I know the group.
That's why I'm having moms on here, because you know what?
I mean, we all know the group. We all know the person.
That other crap.
Right, but they're trying to get a rise out of you. It's
yeah.
No, I get it. I get it more than anybody. But what I'm saying is, can I sue Op-Exposed CPS and Kara Zimmerman, that scumbag piece of shit?
You can sue whoever you want.
You can whoever you want.
All right.
Burden of proof's on the moving party.
Kara Zimmerman and the bearded lady, you're being sued, bitches. All right, can I say that?
Oh, God.
Sure.
All right, it doesn't really matter. I don't care. I just know who it's coming from.
It's the perils of the job.
And I'm sure she's very happy that I said her name, because she is a scumbag.
Hey, I'm going to claim occupational hazard with this conversation.
Right.
I want
Good
hazard.
night, everybody. I love you. Get ready for a lawsuit. Op-Exposed CPS. Good night.
Thank you for tuning in. Thank you for your support and your shares, your likes, and your comments. Even the ones that we don't necessarily agree with and like.
Oh, they agree.
We don't necessarily at Kirk's Law Corner support some of what Ted says. Sometimes Kirk's Law Corner doesn't even support what Kirk says.
Sometimes I know I don't even support what I say. Like, that sounded better in my head.
Ow, I'm human. I had to pinch myself. I am human. I make mistakes. I lose it too. So